We have two land use cases this morning, Commissioners. Our first one's RCU 2015-7 American Tower. Emily Collins with our Planning Department will be talking through the case.
Good morning. As stated previously, American Tower RCU 2015-7. This is a request to renew an expired conditional use permit for a communications tower. So here we have the site, which is outlined in the light blue. It is on the south side of the cul-de-sac on 69th Avenue. That would be east of Washington Street, west of York, and then south of I-76 and the 270 interchange. So again, here's just an aerial view to outline the property. To the north is a vacant lot, and then the other two properties do have buildings on them. The future land use map does identify this as industrial. So previous requests on the site, March 6, 1995, the Board of County Commissioners approved a plat for Lot 4 of the Boco Industrial Park filing number 1 for the subject property. October 30th of 2000, the BOCC approved a conditional use permit to allow the commercial telecommunications tower of 70 feet in height on the subject property. Then again, on May 1st, 2006, the BOCC approved a major amendment to extend the expiration time for the approved CUP for the tower. And there have also been several violations in the past dealing with outdoor storage without a permit, junk on the site, and weeds. However, these violations were unrelated to the operation of the telecommunications tower, and there are no current violations on the property. So again, it is located south of I-76, east of Washington Street on 69th Avenue. The surrounding area is composed of A1, R1C, C5, I1, and I2 zone properties. The future land use map designates the site as industrial, and the goals of the industrial areas are intended to provide a setting for a wide range of employment uses, including manufacturing, warehouse distribution, and other industries. This may also include limited supporting uses such as retail and outdoor storage. And a telecommunications tower does conform to the uses allowed within industrial areas. Per section 324.7.4 of the development standards, the maximum height of a structure shall be 75 feet in the I2 industrial zone district. So the subject request is for the expired conditional use permit. The original permit was approved October 30th of 2000 and then renewed in 2006. However, that did expire on May 1st of 2011. So prior to the expiration, 2 notices were sent to the applicant, which at the time was Sprint Nextel Communications, and the property owner, Lawrence and Loyola Boco. On May 11th of 2011, a representative from American Tower did email staff to inform the county that the property owner and its clients would be submitting a renewal application soon. However, the application was not submitted to Planning and Development until March 2nd, 2015. So the applicant indicates the existing freestanding tower along the I-76 corridor, which is between I-25 and I-270, is essential in order to provide continued wireless coverage in the existing network. The applicant submitted coverage maps provided by the 2 carriers on the tower, Cricket and Sprint, and its staff's determination based on the provided coverage maps that the existing tower is a necessary component of the overall network. So here we have the Cricket maps. So the top one shows the darker green, which is maximum capacity, more coverage capacity, and the bottom one would be if the tower were removed. So all of the towers indicated on these maps are where the Cricket Wireless Company is located on existing towers. So by their mapping, they would show reduced ability to cover in this area. Similarly, we have the Sprint coverage map. The darker blue would show a loss in coverage. So the existing tower is designed to accommodate several carriers, and it is currently 73 feet in height with a traditional monopole construction with panel antennas. All the equipment is located within a prefabricated shelter in a 1,600 square foot lease area surrounded by a 6-foot chain link fence. The shelter is also located behind screen fencing enhanced with vegetation which surrounds the subject site and is therefore not visible from the right-of-way. The applicant has chosen to renew the permit for the freestanding facility as several of the carriers continue to lease space on the tower to provide coverage for their customers in the area. The subject site was originally chosen with the goal of minimizing visual impacts from the tower and blending into the existing industrial landscape and the light poles located along the interstate. So per section 49273D of the development standards, a minimum separation distance of 1,000 feet is required between two towers. There is currently a tower located at 901 East 68th Avenue, which is approximately a quarter mile to the west. That one was approved by the BOCC in 1996, and the distance to this tower is more than the minimum 1,000 feet. In addition, per section 49273E, the 500-foot minimum distance is required between a freestanding tower and dwelling units, and there are no occupied residential dwelling units within the 500 feet. No citizen comments were received for this case. The Transportation Department commented that the subject site is not within a flood hazard area and not within an MS4 permitted area. However, if they plan to install over 3,000 square feet of impervious surface, then a drainage analysis and report would be required. The applicant is not proposing any changes to the site. The City of Commerce City and Xcel Energy have no comments or concerns, and CDOT commented that any utility work in the state highway right-of-way will require a permit. The Tri-County Health Department stated there are several landfills within and surrounding the subject property. Therefore, a flammable gas investigation plan is recommended prior to construction. So although the applicant is not proposing any construction, these requests have been incorporated in the recommended conditions of approval. So again, we have a closer view of the site. So Franklin and 69th Avenue to the north. The box in the orange would be approximately the lease area. You can see the chain link fence here with the tower. So here we are looking into the cul-de-sac west on 69th Avenue and rotating the view, the other building looking west. So it's looking southeast at the subject site. So again, you can see there's screen fencing and vegetation. So it's looking directly south, a view of the tower behind the fence. This is looking into the site. So again, you can see the chain link surrounding the equipment shelter in the lease area. Just another view looking south. So looking directly north on 69th Avenue at the vacant lot. So then again, this would be I-76 right here and 270 above that. So looking northeast into the cul-de-sac, so this would be 69th Avenue. Again, looking east, so Franklin Street would be at the end here. See the enhanced vegetation with the screen fencing. This is looking the opposite direction from the corner of Franklin and 69th, looking west into the cul-de-sac. So just looking at the intersection again more closely. So the Planning Commission considered this case on April 23rd, 2015 and unanimously recommended approval. The Planning Commission asked the applicant why it took American Tower 4 years to renew the permit after receiving notification of the expiration in 2011. The applicant was very apologetic and stated that there had been a lot of staff turnover and the person who had previously communicated with county staff was no longer employed by American Tower. The applicant had no questions or concerns with the staff report or the recommended conditions of approval. So it is staff determination that the request conforms to section 4927 of the development standards and that the tower is necessary to allow continued wireless coverage for this area. The applicant has designed the tower to be minimally invasive while meeting coverage objectives for a large area. So Planning Commission and staff are recommending approval with 7 findings of fact, 5 conditions, and 1 note, and that concludes the staff presentation.
Thank you very much. I have a question for staff. How do we track this process? Because if this was something that was submitted or we knew about, how did it fall through the cracks? And the second part of that question would be, what steps have we taken to prevent that from happening in the future?
So we do have a list of expired permits, and the Planning Department does send out the expiration notices. We are also working with the Code Compliance Division to make sure that we send them the appropriate notification as well so that they can cite any property in violation. And last year we did do a conditional use permit expiration analysis and compiled all of the permits that had been expired and sent that list to the Code Division as well.
So I guess that didn't really answer my question because this has been 4 years and we're just now bringing them to the table to finish this process. They've been operating for 4 years without the permit.
Right. I mean, they were notified several times, and it's up to the applicant to come in and make the application.
So the American Tower is who you're saying is being notified, right?
And the property owner as well.
and American Tower told us, or told the Planning Commission, that it was because of one individual or staff that has been changed, but this is over 4 years.
Right, so it was on the American Towers staff
Right,
end that
right.
that person was no longer in communication with us.
And what are our remedy options for this? I mean, if they do not come in the first year when they don't finish their submission, what is our remedy option from there?
So we would work with our code division to cite them if they're in violation of any permit or conditions of approval. And then from there, we do have performance bonds that are typically required with these permits so that we could remove it if it was no longer active.
So, one, I would ask, did we do that? And two, I would ask, the performance bonds, is there one on this?
Code did work with them to notify, and I would look through my report here. Give me 1 second to check on the performance bond. Not have one previously, but that is condition number 3, that they shall come into compliance and submit the bond. And that should be submitted today, actually.
Okay, and can I ask, other than citing them, because you said that our code compliance would cite them for not being in compliance, right?
Correct.
Is that what was said? Did we ever do that?
Yes, I believe so, but I would have to refer back to the code compliance supervisors to double check on that with their staff.
Commissioners, any questions? Commissioner Henry?
So other than citing, I mean, we could sit there, you know, and keep putting tickets on the door, but do we do anything else other than that? I mean, 4 years is a long time.
Commissioner, at this point, the only remedy that we have would be to double or triple any applications for building permits for co-location of future antennas on the pole. That's something that this board and the Board of Adjustment has done in the past, sort of as a penalty for noncompliance with county regulations. It does require additional staff work and time. When we have applications that have not followed the permit requirements as far as expiration and so forth, we often have to go out to the site either through code or the planning department to verify if the tower is still in operation, what the conditions of the site are, because we're not aware of the parameters because the permit has expired. So that's something the board could consider, is doubling the building permit fees on this tower for the next 2 applications if you choose to.
Okay.
Commissioner Odoricio?
Well, since this is a conditional use, to me, the applicants need to understand that this is done for a specific purpose, and I would fully support some type of a penalty in fine form or something, because it's a conditional use, and they need to understand that, and should. I just think this is a poor excuse.
I do have a question. Obviously, a lot of times when we have these land use situations come up, we look at the history of the applicant to determine whether somebody's a good neighbor or whether they have a history of complying or they have a history of not complying. I guess I have more of a legal question or a process question, and I'm going to start off with saying it's not the planning department that does the enforcement. Am I correct or not correct?
That's correct. We're responsible for notification, which was completed in line with our policies.
Right, and so now we have a new code enforcement. We've reorganized the entire code enforcement division, correct?
Correct.
So I guess I'm going to look forward, and then we'll look backward. But looking forward, how do we prevent this from happening in the future is a big picture question that I think we need to address maybe after this application or during. But I guess right now I would ask legally, is this even the proper forum to be assessing penalties, or would it better be a forum for us to do a show cause hearing?
So Commissioners, I think that penalties would usually be associated with a citation, and a process that would be handled by our office where a property is cited, and if there's no compliance, then our office takes it on as a legal action and can file a civil action, either an injunction or a civil action for penalties. That did not happen in this case. As far as we know, this particular property was never referred to our office for an action. And so I think that's the appropriate venue to punish someone for noncompliance, is through that action. Christine Franciscani from my office is here and said that the applicants did have some comments during the Planning Commission hearing about how they intend to ensure this doesn't happen in the future, so perhaps you can talk to the applicants about that. But I can tell you, I'm not sure if there's a specific provision I'm not aware of in our regulations about doubling fees, but generally speaking, I would not be comfortable with that as a remedy in this situation.
Thank you. And the reason I bring this up is because I have the same concern, is that I think we have two different forums here for two different issues. Now, I think it's entirely appropriate for us to determine the history of an applicant whenever determining whether you think that they're going to apply in the future. That's fine. As far as a punitive or corrective action outside of either denying or approving based on history, also, I think we have to look at the criteria of this. And I'm generally concerned that we have a situation where the tower obviously is a very passive use, but the behavior of the applicant in this particular neighborhood by not complying is something that I think that you can look at under this criteria. When I do look at the criteria, you could determine if they've looked at all off-site impacts. And my question would be, is one of the off-site impacts is a consistent non-compliance with code in the past. Also, the question of whether this particular conditional use permit is compatible with the surrounding area. I think generally the use is obviously compatible. The question would be, is in every case, which special use permits are on a case-by-case basis, I believe you might be able to, or should be able to apply on a case-by-case basis the actor and the applicant as well. I think we could deny this, but I'm not going to recommend it. I think that we need to take action through other channels. And I also look forward to hearing from overall how we as a team are going to be addressing these issues in the future. So we have these issues where planning notifies code enforcement, and then we have the county attorney's office involved. But that's, once again, a bigger picture policy question that I do think needs to be addressed. But once again, this one may not be the right venue. I'll leave that to my other commissioners.
So I just want to say that today we're here to either approve or not approve this application. We do it by the basis of what was presented to us. The questions being asked today, other than one specific question for penalties, was to not repeat past practices that we've fallen into. We need to have a clear picture of how this came to be, and that was the reason for these questions, because we are going to base our decision based on the parameters that are put before us. But I want to make sure that we don't put it off to a point of, we don't put on record that there is a problem, whether the problem is on the applicant's side or whether the problem is on our side. And we want to make sure they're addressed on public record so that we can address those issues within future meetings or future decision-making. This applicant, I commend them. They came in, they did the work. They have done, accepted the responsibility of not following through. I think we need to accept the responsibility of not following through also. We need to fix that, and I think that is a position for a future meeting and future council. For this meeting, though, are there any other questions about the process and the applications? No. Would the applicant like to step forward and make a comment at this time? Please state your name and address for the record.
Good morning. My name is, can you hear me? My name is Victoria Chenault. My address is 1220 South Fillmore Street in Denver, Colorado. I am legal counsel for American Tower, representing them for renewal of this application or this permit. And we admit that this particular permit did fall through the cracks due to staffing changes, a number of restructuring and reorganization, and finally, it was decided internally with American Tower to have all permits not be with staff, but be with the legal department at American Tower, so that they can more closely monitor the permits and more properly reapply for permits before they expire and before, because we found that traditionally, staff level has a tendency to have high turnover. And as a result of this, this is what slipped through the cracks. And so we apologize for that, and we're taking active measures to resolve it in the future.
Commissioners, any questions for the applicant? Commissioner Odorizio.
It's not just the expiration that concerns me, it's the prior noncompliance with the other code that concerns me as well. It said that there was other citations. Do we know what the nature of those other citations were, Emily?
So in the past, the property had been cited for junk, weeds, those sort of violations. But those have been cleaned up, and there are no current violations.
Thank you.
Any other questions? No other questions. Thank you very much.
Thank you.
Is there anyone in the public that would like to make comment at this time? Seeing none. Commissioners, do we have a motion?
I move, Chair, for approval of 7 findings of fact, 5 conditions, and 1 note.
Commissioner Henry,
Yes.
Commissioner Pulowski,
Yes.
Commissioner Hanson,
Aye.
Commissioner Odorizio, Commissioner Tedesco.
Aye. Thank you very much. Next.
Our next case is PRC 2014-16. The case is Antunes Rezoning and Subdivision. Chris LaRue with our planning department is going to be the case manager on this.
Thank you. This is the Antunes Rezoning and Minor Subdivision. It's case number PRC 2014-16. This one had originally come to our attention. They had requested a change in use permit, and we discovered the illegal subdivision and some other things that I'll talk about. But basically, it's a request to rezone a portion of the property from R1C to C1 commercial, minor subdivision to create 1 lot in the C1 zone district. Here's the site and the surrounding area. This is Pecos and 70th, and here are the parcels that they wish to rezone and then combine into 1 lot. And you can see how this one parcel has dual zoning on it with C1 and then R1C. So the idea is to make uniform, consistent zoning on that overall development. The surrounding area is zoned R1C, R2, C3, and C5. It's on the southeast corner of Pecos and 70th. And again, they're zoned C1 and R1C, have a total of 1.04 acres. Surrounding area is similarly zoned with commercial properties and some of the residential. Comprehensive plan designates the site and surrounding area as urban residential, and the subject property has 3 lots with several 1-story active retail buildings. 2 of the lots are already zoned C1, and it's the 3rd one there that has the dual zoning, and that, as you saw on the map, that's on the southeast rear portion. So lot 1 is 0.14 of an acre. It has an existing convenience store. Lot 2 is 0.18 of an acre. It's vacant, but would provide additional parking for the retail buildings on the new subdivision. Lot 3 is 0.72 of an acre, contains several active retail stores fronting along 70th. And part of Lot 3 is contained within the Calcivic Heights subdivision. However, the rest of Lot 3 and Lots 1 and 2 haven't been subdivided, and they were created after 1972. And the minor subdivision final plat would include all 3 lots and correct an illegal subdivision to conform to Adams County and Colorado Revised Statute standards. The appearance and use of the property would remain the same as it has for many years. Combining the 3 lots into 1 could potentially facilitate future redevelopment for commercial purpose on that lot in accordance with the comprehensive plan. It's also important to note by ultimately rezoning the R1C portion to C1 that would mean that no new single-family home entitlements would be granted, as the site's already developed with commercial properties. The Transportation Department states that drainage improvements are not proposed for the site. Initially, site improvements were not identified or indicated to be needed, but as the review progressed, transportation indicated there are no sidewalks in the property, therefore requiring the applicant to construct the curb, gutter, and walks. The applicant would be required to include this information in a subdivision improvement agreement. It would also indicate when the improvements would be installed, timing. CDOT responded with no objections, as they stated the proposal wouldn't have an impact to the state highways in the area. Excel Energy had requested language depicted on the plat for the subdivision concerning utilities. That's reflected on the Mylar. During the conceptual review meeting staff had with the applicants last summer, it stated the applicant should endeavor to create a plan that's consistent with the landscaping requirements as contained in section 416 of the Adams County Development Standards. Specifically, the subject property is either front Pecos or west 70th, and thus landscaping must abut adjoining right-of-ways as described in 416-1901, which lists options for designing that plan. It's especially important given the property's high visibility along Pecos Street, and that's included as a condition in the case. So the Planning Commission considered this case on April 23rd. They had recommended unanimous approval. The Planning Commission recommended an additional condition stating the applicant should repair the parking lot located on all of the sites and make sure that the spaces are adequately striped. No citizen testimonies presented during that hearing. No concerns were expressed with the staff report or recommended conditions of approval. The applicant has not provided a draft of the subdivision improvement agreement as of today, so we don't have that available. Here at the end, I'll outline several options for you to consider regarding that matter. But basically, this is the site plan for the property where you can see the existing building or retail space. This is the convenience store that needs the change in use. This is basically just the subdivision that shows what the new lot would look like as it's combined into one. Here's a high-up aerial view showing Pecos and 70th. You can see Highway 36th here. This is the Midtown development down here to the southwest. So then here's a closer view. Again, 70th and Pecos. Excuse me, here's the site then that is presently, it consists of three parcels. And the R1C section that we saw or the single-family section we saw on the zoning maps down here in this corner. So obviously it's not utilized for that. Here's just another view. North would be to the bottom here, Pecos and 70th, just showing the retail space, showing the lack of curb, gutter, and walk. We also don't have it on this parcel, but the idea is that we would want it installed here so that it would join up with what's further to the, I guess that'd be the east on this picture. So we feel that's an important component. Here's south on Pecos. This is the site over here to the left or to the east. Here's north. This is along Pecos. This is 70th here at the corner. So this is the site. You can see on both these pictures there's a need for some updated landscaping. It's just another view looking north on Pecos here at the corner of 70th and Pecos into the site. Another view, just kind of moving northeast. Here through the gap, this is 70th Avenue. So this is east on 70th. This is the property frontage. And obviously you can note there's no curb gutter walk there. There is some over on this side. That's looking west then towards Pecos, which is here. And this is along 70th and the property frontage. That's a little further back, but looking west again towards Pecos. This is 70th. Here's a site facing south, looking at this existing commercial building. So by combining the lots, the applicant would be eliminating this illegal subdivision, ensuring uniform zoning on the entire site. So all those are good. In addition, it could be easier to develop if it ever got redeveloped in the future at some point. For the foreseeable future, it'd continue to be used in a similar manner as it has in the past. So we feel like the proposal ultimately would be consistent in the area. And originally, we were recommending approval with a condition precedent, 2 conditions in that note, but due to not having the SIA available, there's several options that we'd like the board to consider. One would be continue action to June 16th, 2015. That would allow the SIA to be completed by the applicant, reviewed by staff. We could present that as a complete package then on the 16th. We could adopt a condition that the applicant has until June 2nd to submit the SIA, or else the case could become void, or we could just simply have a condition that states the applicant shall submit the completed SIA by June 2nd. Second and third options, especially the third one, would mean that the site would be ineligible for any building permits or other land use applications until they completed that document. And as I'd stated, there is an outstanding change in use. But those are the three options that we're proposing with respect to the SIA. That concludes the staff report.
Commissioner Hanson.
You know, we've always had, not always, but we've had some issues with SIAs in the past. And I think that we've cleaned up that process, and I really like, kind of where we're at today. And my personal opinion is that I like to be able to see what exactly it is that I'm approving. So my personal preference would be to continue the action until the 16th of June, to allow that SIA to be completed so that we know what we're doing kind of as a package. That's my personal preference. I would like to hear from the applicant to see what they have to say about that, because I don't know if there are other implications to continue it, but it doesn't seem like it's it doesn't seem like it's that far away, unless there's something that I don't know.
I did want to make one comment relative to the SIA. We have provided the draft to the applicant. I followed up a couple different times asking about the status. We really wanted to have it prior to Board of County Commissioners. That's always the goal.
Commissioners, any other questions for staff? No other questions for staff. I'll say this on this. I do want to point out a couple things, not that it has anything to do with how I'm going to make my decision, but I think it's important. And that is that Pecos is a very busy intersection. There is a school on the west side, and there is a school on the east side. And the ability to provide safe routes to school is high on the commissioner's agenda. And to see that being acknowledged in this is absolutely wonderful. So I just wanted to point that out. So thank you. All right, no other questions for staff from the commissioners? Would the applicant like to step forward and make a comment? Please state your name and address for the record.
Range, 6380 South Netherlands Circle, Centennial, Colorado, 80016. I'm the representative of the ownership of the property, which happened to be present at this point in time, and you can ask them any more specific questions. As a little background information, we're kind of, as you had mentioned, falling through the cracks. Well, I feel like I'm picking up dirty socks here, because when I first realized that this property had an R1C zone in portion of the building that was already constructed, I said, how did that happen? And as an architect and a contractor, I was just kind of, in a fog. So I made the trip to Adams County, and from that point, actually, no one here could really tell me how it happened, but we deal with what we have to deal with. So that started this whole process approximately 6 months ago. From that point, not to belabor the issue, I suggested to the ownership that to clean it up, what we ought to do is combine all three parcels into one subdivision, because that was the regulation anyhow, and it just seemed a very logical process to go through. So that's where we are today. As far as the request from the planning department to take a 10-foot wide section from the property facing on 70th Avenue, the owners agreed to it, I agreed to it, and the documents that basically I've prepared resemble that, as well as the subdivision plat. During these numerous meetings, it was mentioned to the owners and myself, everybody in the discussion, that at some point in time, Adams County will be widening 70th Avenue, and at that point in time, they would secure that property. And I said, fine, that's good, and the owners understood that. It was also discussed the current condition of the access off of 70th Avenue, and it was relayed to them that nothing had to be done at this point in time. And then all of a sudden, the SIA document came up, and I guess the request for some kind of, what I want to say, guarantee, if you will, to provide sidewalk and or curb cut and or anything else that the county would would require. The owners don't have any problem with doing that. In my discussions with Mr. LaRue at the planning department, I said, well, Chris, don't you think it's a little kind of ridiculous to construct a sidewalk, and if in 10 years or 5 years or 2 months Adam County decides to do the right-of-way and we have to tear up what we just did? Now, as a point of fact, the sidewalk where I believe they requested has 2 large XL power poles right in the middle of the sidewalk. So again, we have a little conflict here. So I think everybody concerned agrees that, yes, a sidewalk, yes, we'll put it in. Yes, they understand that it has to meet the regulations, but it's a matter of when and what are the requirements that are going with the rest of the property. They're already prepared to do the site plan for the Pecos lots, which includes the landscape and the sidewalk that exists there today, and to get rid of the curb cut and plant the trees and irrigation, et cetera. They've already agreed to the parking lot marking, and of course, we're going to be tearing up a lot of that just to get all that done. So we have a little things like an order. Let's do that first, and then we can talk about what we have to do for 70th to appease not only the owners and the planning department, but the county commissioners, and I'm the least guy of importance in the whole picture. So if you'd like to ask something of the owners, they're here to answer any questions you have.
Commissioners, do you have any questions for the applicant? Commissioner Odorizio.
I feel like sometimes we're picking up dirty socks along with you. I think that what I see as a good faith effort by staff to work with the commissioner's vision to try to promote curb gutter sidewalk, better aesthetics, and safer routes for not just our pedestrians, but also our kids that go to and from school. I appreciate your willingness and your client's willingness to address that issue. I could tell you just about every week now when we have a hearing on land use, we're hearing questions or concerns about, well, if we don't, why would we want to put in curb gutter sidewalk now if it's going to be widened later or if it's going to be done later? Well, the bottom line is we're asking that from everyone right now, and it is a challenge, and the question usually comes, why start here? The bottom line is we're starting everywhere, and we're doing the best we can to try to promote a safer environment that looks more aesthetically pleasing. And I think that I'm actually very happy about where this whole process is going with this property, because I think the applicant's going to get a more marketable property. It's going to be fixing some sort of zoning conflict, however it started, I don't know. And it's also going to fix an illegal subdivision. So I think that at the end of the day, in this give and take and working with the community, I think this will be a win-win. And I would ask that we include the curb gutter sidewalk implementation and landscaping right now as we go. And my recommendation is to design it in a way that you don't have, that you can minimize the amount of tearing up you may have to do in the future. But thank you very much for your comments on that, and I appreciate this. And the only other concern I would have is I think I'm very supportive of the overall concept of this application, but I also have to agree with Commissioner Hanson that I think my question, I guess, to you is, would there be any major detriment or burden on your applicant to wait 2 or 3 more weeks for this agreement to be finalized?
I don't know, you'd have to ask them, but frankly, I think the only thing that, and correct me if I'm wrong, Mr. LaRue, the only thing that we're really discussing is the sidewalk, where it goes, when it goes, and they're willing to pay for that. So I guess my point would be, or my question would be, can we make the sidewalk placement so that it reflects the widening of 70th down the road? So otherwise, find out where its permanent home is going to be and put it in there, and then I don't think we're really talking about much.
So at this time, I think that Mr. LaRue would like to
Yeah.
make some clarifying remarks.
Well,
So
the answer to his question regarding timing the landscape in with respect to future build-out is obviously 100% yes. We want that to occur. The plat currently reflects a dedication of 10 feet of right-of-way, so we're already having that in mind with the development of this site. So in terms of the sidewalk, curb, gutter walk improvements, with subdivision, those are typically required with the subdivision, so we would expect those to occur soon. That being said, the SIA itself, the documentation then would present the timing issues in the document itself in terms of expectations of when that's completed. We'd want to make sure that that's relative to any potential plans that may be on board for 70th. But that right-of-way would be dedicated, so the expectation would be that improvements, landscaping, which we feel is extremely important, it's part of a condition in the staff report, all that would be done on the interior of the right-of-way that would be dedicated, so that none of that would be ripped down or damaged in any way, but function as we move forward. I think that's all I really wanted to comment on.
Okay. Thank you very much. Would the applicants like to come up and make a statement? I think there was a question for the applicants themselves as to the timing and whether or not it would be detrimental for us to wait another few weeks. Please state your name and address for the record.
Okay. My name is Sylvia Antunes, and I live in 3821 South Exante Street, Denver, Colorado, 80237.
Okay. And could you answer the question as to, there was a suggestion that we wait until the SIA is submitted, which would delay us making a decision or present the presentation to us, I believe, how long?
June 16th.
June 16th.
What we'd suggested.
And whether or not that would be detrimental to you in any way.
I don't know what is a CIA,
SIA.
SI.
So I can address that briefly. It's subdivision improvement agreement, and it's a document that helps us with timing and expectations of public improvements. And I had talked with Mr. Raines regarding the draft that we'd sent, and he had indicated to me that he'd discussed it with the applicant thoroughly. They were trying to talk about timing, et cetera, of that document. And so in terms of impact, the store is already being operated without a change in use permit. I mean, I'd argue that a couple of weeks wouldn't really pose any impact to her in terms of what she's doing. But, yeah, obviously, I think it'd be beneficial that they come in and meet with us after this meeting at some point so that we could further clarify that. Obviously, we were a little frustrated with the SIA ourselves, but.
So to ask the question is, are you comfortable with waiting a couple weeks so that we can get all the proper documentation in order?
We are agree. I mean, we want to do and make our property looks nice and make the improvements, and of course for the children of our neighborhood, we want to secure them, and we are comfortable with that.
Thank you very much. I
You're
appreciate
welcome.
your comments.
You're welcome.
Any other questions for the applicant? Seeing none, is there anyone in the audience that would like to make a comment on this application? Seeing none, commissioners, do we have a motion?
Mr. Chairman, I move to continue this case until June 16th to allow the SI to be completed.
Commissioner Hanson?
Aye.
Commissioner Odorizio? Commissioner Pulowski? Commissioner Henry?
Yes.
Commissioner Tedesco?
Yes, thank you very much. And seeing no further business, we are adjourned.